I am the managing partner at Law Accent. Today, I will be the anchor for the session that we are continuing, something about intellectual property rights for techpreneurs. Today, we are going to focus on patents. My duty would be to help you to eat in the event that you come up with one. Okay, so let's start this way. Let's start by trying to understand what is a patent. And then, as my practice is, I'm going to give you some shockers, so that those shockers are things that you take home with you that would make this session to really sink inside. So let's start with what a patent is, and probably too what a patent is not. Now, usually when you get involved in works of creative effort such that you are able to give birth to something that has never been in existence, or you are able to build on something that has been in existence. Now, building on could mean that you did something that makes life pretty easier than where life used to be before that thing that you did. So if you are able to come up with all of these things of being produced in mass and sold in commercial quantity, in that event, you're said to, you might have just made or created, you can protect and then have exclusive rights to. So let me give an example of what I mean by if you build on something from the state of art, meaning from what we used to know, and then you were able to build on something. So I'm going to give this example. There was the time when if we needed hot water, we would usually use something called boiling ring. Now, the boiling ring was an invention at a time, very fantastic. Something you want to make your water get hot very fast. In fact, some people would use it to even boil stuffs and all of that. Very fantastic idea. But then, somebody somewhere or an entity somewhere came up with the idea of, if you need water to bathe, why not let's make an engine that can be connected to the bathroom, whereby once you switch the button, then the water becomes warm and then it becomes hot, depending on how you want it. And then they came up with water heater. Now, this is a fantastic example of building on what is called the present position of things, which the law refers to as building on the present state of art. So this is what intellectual property, as far as patents, is all about. So you would find from everything I've said so far that you have come up with something that is unique and has never been seen, or something that has been seen on a lower level, but now you are advancing it. So that's to show that there is a high level of inventive exercise demonstrated in betting that thing. And in all of these things, you must have produced something that in the real sense is not exempted from what qualifies for patent. So you can imagine if you produce something, well, people can create things, but people can also create things that are not morally right or are contrary to public policy. Now, these are examples of situations where such invention, even though an invention, will not be protected under the law. So you see, these are fantastic things that you need to know as a foundation for the word patent. So in summary, patent is a work of invention which you created and by reason of which you are given an exclusive right to commercialize that invention. That summarizes what patent is. I said I was going to give you some shockers. So let's start with shocker number one. Number one thing, are you aware that the fact that you are the inventor of an invention does not necessarily mean that you would have the right to it? What do I mean? If somebody else goes to register something that happens to be your invention, the person would be given the right to the invention in the place of the inventor. At best, you have a right to be recognized. You were the one that did this beautiful work. All well and good. We recognize that, but we registered it. And that simply means, as far as patent protection is concerned, he who registers has the right to the use of the patent and not necessarily the owner. Now, don't be scared about something. I know something will come to your mind like, what if I had shared this thought, I had put everything together, and then one of those people I shared it with, rushed ahead, got it done before me, and did. This is where you need to be wise with your inventions, which is one of the reasons we usually say you must find every means as much within your ability to ensure that there is a non-disclosure agreement signed with people you are sharing your thoughts with. And another thing is, when you have expressed all of these thoughts, let's assume you express them but not registered and all of that, and then somebody else gets to register it and all of that. The law envisages theft of ideas and theft of work. And that is why there's a provision that protects you, such that if after that happens, you are able to demonstrate that that work happened to be your work, and the whole of what is contained there, the device, the system, they could have adjusted a little, but if you're able to demonstrate that the work was born out of your work, then you might actually have a right to be protected in that instance. So I hope it doesn't get to you as such. So I want to touch on something which always is very important. What happens in a situation there is an employment relationship between two people, between the employer and an employee, and in the course of that relationship, the employee gave birth to a work of invention. The question is, who owns the invention at that point? Now, the law is clear about this, that in that situation, the employer ideally has ownership of the work. But we need to take it further. Another question could be, what if exercise was not part of the job description or part of the normal thing that the employee does at work? Because this is a peculiar situation. You engage me to be a front desk clerk. In the course of, I was doing my work as a front desk, but then some other ideas were in my brain, and then I put in effort together with my employer or myself alone, even though, all of these things I did within the walls of the building called my employment building, called my office. This is a peculiar situation. So what happens in that situation? Ideally, what the law recognizes is in this kind of situation, the employee has a right to compensation. Unfortunately, because compensation is a relative thing compared to the value of whatever is created. An employee, a $1 billion invention and is compensated in hundreds of naira, it doesn't make up to anything. But this is a loophole. But then, as far as the employment relationship is concerned, that's what it is under the law. Now let's look at another one. What if you decide to assign your right in an invention to a third party? If you decide to do this, or let me speak from the two sides of the coin, what if you are interested in getting an invention assigned to you as a businessman, or maybe you needed the invention to push your work or even commercialize it? Perhaps you have the fund. What happens in this situation? Now, what the law envisages is the number one thing is to protect yourself. You must ensure that there is an assignment, there is an agreement by reason of, which transfers the right to the patent to you. And the second thing, this is where many people miss it. You do not have to stop at signing documents. The law mandates that such document has to be registered with the design, which is where many people miss it. And of course, when they do not do this and then something goes wrong, it has a way of coming back to affect the business and the rights which you should have to the patent as a whole. So here is where you need to take precaution and ensure that you get it done properly. Now, the next thing is, I want to address you if you own rights in patent and you're looking at assigning or licensing or anything. You need to understand that the fact that you want to license does not mean you have to give everything about your invention to a third party. What I'm saying in essence is, if I invent, if I give birth to an app that is capable of doing 10 things, and then I want to do an assignment, I necessarily do not have to give all the rights in the whole 10 different things the app can do to a third party. I can negotiate on some of the rights and have exclusively the rest of the rights. So what I'm saying in essence is, you have the option of licensing limited parts of your rights, or if you wish, you could make it a general license where the person you're licensing to has right to all of exclusively to all of the benefits and attributes that relate to your invention. So these are things that you should consider before too far. Now let me go to how do you protect your patent? Because of course, if you need protection, unlike copyright, if you need protection for your patent, you have to register it. But I dare say as well that we've had situations of inventors choosing to keep what could have been patented as a trade secret. I believe that was explained by my colleague at the last session, the Facebook Live session, just Thursday last week. Now, we've had situations of people that opted to keep their patent to themselves as a trade secret. And then we've had those that preferred to register as a trademark. As a patent. Now, in this situation, if you prefer to register your patent, how do you go about it? So let me give you tips for going about it. The number one thing is, usually it's better you act through an agent that understands how to go about all of these things. You need to opt for an agent. You can get a law firm. It's also one of the things that we do at Law Accent, so you could opt to get it done through us. Then the next thing is, you need to do your search. You need to be sure that something of whether exactly the same nature or very similar to what you want to patent is not in existence in the archives of the registry. Then the next thing is, when you show up all of these things, you then need to put expression, detailed explanation of your patent, the background to it, how it works, the unique thing about it, and all of that. You need to put all of these things in paper. If there is a diagram or a design or something, you need to put everything together. When you do all of these things, this would form the basis of what you are applying to protect. Bear in mind, which is very crucial, many people make the mistake of just putting together a very shallow explanation of their patent. And the problem with that is, when you do that, it limits the scope of your protection. You can only be protected to the extent of what you have registered with the registrar. So when you make a shallow explanation of your device or your invention and how it works, then don't expect to have a robust protection. So this is something you must be deliberate about. You must take your time to put your explanations together, to do all of these things. When you do them, then you are good to go to have your patent approved. And once you have it approved, you can be rest assured that it will last you. You have exclusive right to it for the next 20 years. The but there is the fact that every year you need to renew your rights, your exclusive rights to the patent. Now, you ask me, what if I do not renew? The problem with not renewing is, you may not be able to enforce against third parties. So it is in your interest that you try as much as possible to pay the renewal fee every year, so that you can have maximum. Let me just check. I told you there's a shocker that I'm trying to finish with, so let me be sure that. Okay, so I think I have just one more point, and then I'll go to the shocker. Now, the final point before the shocker is the fact that you have a whole lot of rights the moment you register. The moment you register your invention, you have a whole lot of rights. If a third party is doing anything without your permission, you can sue, you can claim compensation, heavy one. If you find that there is a place you know of, you got wind of, where your device, your patent, your invention is being duplicated, you can get an order to move in and have those things seized and brought before the court for the purposes of destroying them. Now, another thing is, you can even ask for injunction against anybody that is infringing on your right, and a whole lot of other rights that you can take advantage of. Interesting too, even if the registrar by mistake registers another patent, you can compel the registrar to take that registration, to strike it out from the list of patents with it. So you see, you have a whole lot of rights, and this is why you must take your renewal very seriously, because if you are not renewing, that means you would not be able to maximize, to enforce your exclusive rights against third parties. Now to my closing chapter. Did you know that if you register your patent and go to bed, a third party can apply to the courts for compulsory license to use the same patent? Are you aware? Let's scenario to it. If you register your patent and you are not commercializing it enough, COVID-19 is outside, for instance, you get some cure and all of that, and let's assume that you are able to register to patent those cure, and then you do all of these things, World Health Organization certifies it, and then you don't have the money, or you are dilly-dally in producing. Some competent hands that can do better, if they seek for your approval for license and you refuse them, if they are able to establish that there is a bigger market and more need for your patent than you are able to manage, did you know that a third party can get compulsory license to use your patent? The summary of it is this: don't register your patent and go to sleep. Patents are protected not necessarily to even limit competition. It's not necessary to give you a big edge so that you can go to bed. I have an invention somewhere since 1979 and all of that. It doesn't work that way. You are given that exclusive right, assumption that you have all the capacity to bring it on board, commercialize it, and use it to make the world to be a better place. Let me close with this for today. Thank you for being a part of this session. You can feel free to send in your comments, send in your questions, send in your contributions to the question box below. Once again, thank you for watching, and we hope to have you again by Thursday next week. Thank you.